Be seated. Good morning. Now is the time that we've set for oral argument in cause number 1 CACV 160209. And before I slaughter the name, how is the appellee's name pronounced?
I believe he pronounces it GIGUERE, Your Honor.
GIGUERE?
That's what I believe.
Thank you. Like G-I-G-A-R-E kind of thing, GIGUERE.
I think so, Your Honor.
Okay, and I really don't want to abuse it. With the last name Jones, I've never had anybody ask me that question, and I am sensitive to it. This is Adams et al. Versus GIGUERE. For everybody's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems, which of course recognizes that it is possible that there could be problems, you can critique today's oral argument on YouTube in a couple of weeks. Counsel, as is the standard, each side will be entitled to 20 minutes for their argument. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, as I'm sure you are aware, if you wish to reserve any portion of your time for rebuttal, please let us know, and we'll try to keep from beating you up too bad and leave some time for that. However, ultimately, reserving that time is your responsibility. We have reviewed the briefs and conferenced the case this morning. We are well aware of the facts and issues attendant to this argument, and we say that to give you the opportunity to fashion your argument around a realization that we have reviewed the documents and the arguments. Counsel, when you come to the podium, finally, I would ask that you state your name and who you represent so it's clear for the record. And with that, counsel for the appellant, you may begin.
Thank you, Your Honor. And good morning, members of the panel. I am Timothy Lasota on behalf of the plaintiffs' appellants, many of whom are in the courtroom today with me. And I just wanted to start off by saying that the situation that is presented to you, that the variance came to the plaintiffs' appellants, the neighbors, through no fault of their own. It was the Mr. GIGUERE who placed his house in the wrong location. Through everything, it was not caught by the City of Tempe, and their response was to essentially concoct some reasons, circumstances after the fact, anything possible to justify a variance.
Why?
And
Why?
I'm sorry.
Why was it necessary for them to concoct reasons? Why was Mr. GIGUERE the beneficiary of their largesse?
Your Honor, they had a problem that they needed to deal with, and it was this house that was built 10 feet in the setback illegally. So their response was essentially to cast the problem that they had created themselves onto the neighbors through an illegal variance.
How did they create that problem themselves?
Well, it was created because the house was built illegally in the setback, and so the response was that, well, we'll get a variance and that will bless this action.
But they didn't build a house, so how did they create the problem?
Well, Your Honor, they created the problem because through every inspection, this was not discovered. The plans submitted, some problem happened. I mean, this is 10 feet into the setback, but be that as it may, the issue on a variance is whether there are special circumstances applicable to the property. And that's the first test. There are no special circumstances. We have lack of a sidewalk.
Wait. We have questions about that.
You say there is no special circumstances, but we have the report that was prepared by the city, and that's evidence. And in that report it says, and I'm quoting, there is no sidewalk in front of the lot and substantial right-of-way encroaches on the property. The extensive right-of-way would require the house to be placed further back on the lot where existing easements and overhead power lines limit placement. And in reading the transcripts and everything else, I didn't see anything that would contradict that statement.
Your Honor, several things contradict that statement, one of which is the actual plans that were submitted by Mr. GIGUERE, and that his first set of plans was a demolition plan which had his house in the correct location. That was all in the record. He could build the house he wanted to build.
Stop for a second, please. Where do I look in the record to find the support for your statement that the demo plans showed the house in the correct record? I've seen the demo plan, but where do I look as to someone who, a human being, that said demo plans showed house in the correct location? Where is that in the record?
Well, Your Honor, if you look at what the trial court found,
I'm asking the record, the administrative record. Where do I look? Where do I look?
Your Honor, you look at the actual demolition plan, which shows the house. You can see it on the demolition plan. The house is in a different location than on the plan than where the house ended up. That is on the demolition plan. The house was supposed to be 10 feet further back on the property line.
But where is the testimony in the record? In the record, page and line or PDF number, where a human being said the demo plans show the house in its correct location, and thus there isn't any impediment to putting it farther back. Where in the record is that?
Your Honor, I don't know that it was ever actually stated that succinctly, but if you look at the demolition plan, it has the house in a location where the house did not end up being built. So
Wait a minute, and let's be real clear on this. Are you saying that they didn't build the house according to the approved plans, or are you saying they built it according to the approved plans, but the approved plans, one took into account the right-of-way and one didn't?
Your Honor, it is actually the second that you've identified. The plans submitted, there were two different plans submitted,
right,
and the discrepancy was not caught by essentially the plan that ended up going through was the wrong plan. It showed the house in the wrong location.
For our purposes, rather than just talking about plans, what plan was the wrong plan?
Not the demolition plan, but the plan that was submitted subsequently. The demolition plan was actually correct.
Referred to as the engineering plan, I think.
Correct.
Okay.
Yes. But the law in this regard, in order to have special circumstances have to be circumstances that do not obtain everywhere else. Otherwise, it's not a special circumstance, it's merely a circumstance. So when we talk about rights of ways and lack of sidewalks, those are things that affect everyone. That's why the Topanga case from California, which the statute is very...
Excuse me, how do we know that in this record?
Your Honor, well, first of all, the actual Board of Adjustment did not discuss special circumstances. That does not come up any time in their hearing.
Yes, it did. It came up when she presented this plan, this report.
Yes, Your Honor, but you're right, so it's in the record, but that word was not mentioned in the transcript, I do not believe, of their hearing. So they had the report.
Well, there was testimony about this statement. I think she may have been just reading it. My memory is the testimony that she read was this very statement.
Your Honor, I don't think so. I scanned the transcript. I don't think special circumstances even came up in that hearing.
Not have said the magic words, but didn't she say this?
Your Honor, I do not believe.
Assuming she did or didn't, was there any contradictory evidence put in the record or anything that would indicate to the board that this didn't exist or this wasn't just unique for this property?
Your Honor, I don't believe there's anything that actually goes to that, but that goes to the issue of this Board of Adjustment did not have the evidence in front of it necessary to make the determination. It is true that the Board of Adjustment's decision is entitled to abuse of discretion, but they have to have evidence in front of it that demonstrates that this is a special circumstances. And when you don't have any evidence of anything else other than this one property, it is impossible to conclude that it's a special circumstance.
So are you saying that special circumstances are determined upon whether or not there's a substantial percentage of other properties that have gained the same benefit?
Your Honor, I think there has to be some comparison to other properties in that zoning district. Otherwise,
I thought you started by saying that wasn't the case.
It's not. And they would not have been able to prove that if they went around and looked at other properties and said that, well, this is you know, this property has a lack of a sidewalk. Let's go look around and see if that's that's unique or peculiar to this property, or an exceptional circumstance, as the Pond First case said. That's what you have to do. That's what demonstrates a special circumstance. A special circumstance is a property in a cul-de-sac that has some weird shape, and because of that, the setbacks affect you in a way that most other people don't have that same problem. Most other people don't. I mean, a lot of other people don't have sidewalks, have rights of ways, and that goes to another issue. If the encroachment, if the right of way is too big, if the setback is too significant, that is an issue for the Tempe City Council. This 20-foot setback is basically the standard throughout residential districts in the city of Tempe.
Let me raise an issue here, and we'll be questioning your opponent here on this as well. In reviewing the record, it is at least my perspective that it is filled with inadequacies. The discussion we're having right now about where in the record, and your responses are telling me it's not in the record, and we've been asking questions about that. I don't see, for example, anything that says there's a conflict about overhead power lines. And I have no idea from this record whether the overhead power lines affect all of the other neighbors in that contiguous or general area. So the record is just, in my view, it's inadequate. So what do we do about that? Do we say, well, that's pox on your side because you were there, or you weren't there, but you had an opportunity to make an adequate record and you didn't do it? Do we hold that against the other side? Or do we say to the Superior Court, send it back to the Board of Adjustments to do their job and to have an adequate record?
Well, Your Honor, I would say first choice is 2, second choice is 3. And first choice should not be a choice because
number one, what's going behind
number one
number
was
one?
That's our problem. That absolutely, the lack, if there is and I agree with you. I think the Board of Adjustment did a very poor job in fleshing this out. The hearing officer did what someone should do.
Let's respond to my question.
Sure.
So what do we do with the cards we're dealt with this record that leaves us in?
Yes, Your Honor. I think the response is that in order to sustain a variance, there has to be substantial evidence in the record that supports that variance, and that evidence simply does not exist. So I think there are not grounds to grant the variance. So I think that's the ruling from the court. I think just based on this record, there's not credible evidence because you simply cannot conclude there are special circumstances.
Well, I'm afraid that's where I disagree, and I'll tell you why. This report from Ms. Lesser states directly that the extensive right-of-way would require the house be placed further back on the lot where existing easements and overhead power lines limit placement. I don't see anything other than the point that you made about the demo, and that's not even clear to me about the demo map, that contradicts that. So if we want to go based on this record, it doesn't cut in your favor. But in my mind, there are sufficient ambiguities and uncertainties. Should we remand to the Board of Adjustments? I mean, if you want to hit the home run, hit the home run. I'm telling you, I'm not sure you're going to get the home run.
Okay. Well, Your Honor, I think that certainly would be preferable to sustaining a variance based on the record we have, which if this is a legitimate variance based on this record, it's hard to imagine a variance that could come in front of this Board of Adjustment or any other Board of Adjustment in the state that would not be justified. I mean, you can go around I mean, how many properties don't have a sidewalk? Do you have a sidewalk? How many properties have power lines? It is incumbent on the person asking for the variance. This is something that the Pond First case just last April, this court told us is only available in exceptional circumstances. The initial burden is on the applicant, the city, whoever, to basically put facts in the record that would let you know this is an exceptional circumstance. This is not just something that if you went to any other house on this block, any other house in the district, any other place that would exist. That is simply not in the record. So I would say at a minimum, it should be remanded, but when it gets back there, it's going to be the same. It will be the same issue over again, with them trying to come up with essentially reasons that justify an after-the-fact variance for something that never should have happened to begin with.
I have a question on this. Forgive me. Let's say we remanded back. It is after the fact. There's no question about it. It's after the fact. If the city or Mr. GIGUERE introduces evidence before the Board of Adjustments that there are, in fact, special circumstances that I can't envision, but he really does show that, does the fact that it comes, that showing after the fact, make a difference?
Your Honor,
The Arizona cases?
I think the honest answer to that is no, that a variance can be granted after the fact. I mean, I think I think that is relevant to show that these are not real circumstances. This is just the best they could. I mean, what if they would have said, well, the property's rectangular, so that's a special circumstance. And meanwhile,
Counsel, didn't they proceed with the allowance of the city of Tempe?
I'm sorry, Your Honor.
Didn't they proceed with the city's permission? Didn't they proceed on a process of permitting and approvals for things like foundation and things like that?
Yes, Your Honor.
So when you say they proceeded kind of, trying to get it in there quick before anybody knew what was going on, I mean, the city was coming out and doing its regular inspections and things. We know that because of the foundation issues and coming out, and I think there was substantial testimony about how that was approved and how that was gone about. So, I mean, the city was kind of implicit in this to a certain extent in authorizing them to proceed with what then was determined to be an improper construction.
Your Honor, well, yes, it's essentially it's the fault of the city and Mr. GIGUERE that this happened. And when I say this is they come up with these things after the fact, it's because they had to figure out a reason to essentially justify the house being there.
Who?
The city of Tempe and the defendant, Mr. GIGUERE. Otherwise, he's going to have to take his house down or have to remediate in some other way. But it's got to be. I mean, the city's got people in their code enforcement unit who go around and tell people this is not up to zoning code. You need to change that. So when I say they did not plan on getting a variance from the start. If they would have planned on getting a variance, maybe they would have come up with reasons that were better than these. But the house was where it was. They had to legally justify a variance for a house that had already been built based on the best they could come up with. If it wasn't this, it would have been that the lot is rectangular, which I think most people would agree would be a ridiculous reason because most lots are rectangular. Variances, we really have to go back to.
Well, Counsel, you keep saying that, but if what they've stated is in fact the case, and we have to accept it as true because it's the only evidence presented, then that can be the basis for a special circumstance.
Your Honor, I would say if there is evidence presented that this is indeed a special circumstance and instead of just a circumstance, it could be something that is like that, but they would have to say, well, they would have to demonstrate how this property is uniquely and particularly affected. That's a special circumstance is something that you suffer that other people don't suffer as a general rule, and that's why you get a break from a law that everyone else otherwise has to obey, the zoning code. So it has to be something that is special, and it cannot be special unless it's special in relation to other properties in that zoning district, and the record is completely bereft of any evidence that anyone could reasonably conclude that these were indeed special circumstances compared to other properties in that zoning district, and that's the crux of this case.
Counsel,
Is that
as I read the record, there's this ongoing implication, and I have to smile when I say this, but there's this ongoing implication that to require the house to be moved back would involve overhead power lines. I represented municipalities. I would have said, put it into a subsequent conflict or something like that, created a secondary easement violation or something. You understand? Where do we even know that there isn't a special circumstance, that it has to be where it is, or if it's moved back 5 inches, it's going to be put into conflict with the power line easements?
Well, the actual plan on there does show the overhead power lines, and
Which plan?
this is the actual demolition plan. It has, and they're labeled OH. And they run as most power lines do. They run through according to the plan, they run through the alley. Now you have another OH coming to the house, which every house has power lines somewhere. In some newer developments they're underground, but almost everywhere else they're above. And you've got that big cable running to your house, and it is OH on it. It's just, but it goes to show they simply, this is not credible evidence, because there's no comparison, and all it is a couple lines in a staff report that they don't expound on any further. So I think that there's just not
An utter red herring, and I'm not meaning to abuse you at all in saying this. You're telling us that it is an utter red herring in the record for them to continually refer to the power lines in the back as being implicated by any necessary change in the front.
Your Honor, I would say yes. I would agree with that. And I'm
But
sort
no
of...
one ever said that to be the case.
Well, but Your Honor, that goes to the issue of who has to produce facts in the record that you could actually reasonably conclude that these are special circumstances.
Well, we have this. That's what we've got.
Right.
We have that. And I don't see, as Judge Jones just asked you, anyone saying, Board of Adjustment, this reference to overhead power lines, that is not borne out, and here's why.
Your Honor, if you look at the plan, which is also part of the record, that contradicts the staff report.
So what we would need to do as the appellate court is get out our ruler and use the little legend in the corner or whatever's there and be able to measure it off and know what the appropriate distance from the easement was or where the easement existed, and then make our determination?
No, Your Honor. I think as the appellate court, you simply need to be able to say we don't have the evidence necessary to determine that this is a special circumstance. Overhead power lines are not something that jump out as a special circumstance, and there's no evidence in the record that they're special. There's evidence that they exist, yes, but there has to be evidence, credible evidence, to sustain the variance. It's exceptional circumstances only, and there's no credible evidence.
So if we say the variance doesn't get granted, let's just, I know that Judge Norris has gone down through the possibilities with you. I'm not going to do that. The variance doesn't get granted. He's got to move the house back. He moves the house back. It's in the easement, and then he's back in asking for a variance to move it forward? Or do
Your
we
Honor,
get,
I
or
think
do we
he
get the
could-
record complete?
It's a much better. He can ask for an easement to move. If it's actually true that it affects it, which there's a lot. It's not that's not accurate. But if it did affect it, he could ask for a variance to move his house back. That's something he could ask for a variance on.
So the propriety then, in your mind, would be in directing him to move it back, and if that's in conflict, then move it back up again, move it back forward again.
No, Your Honor. I think he has to come up with a solution that is legal. I think moving it back is a perfectly legal solution. I don't think he needs a variance to move it back.
Unless it's in conflict with the easements, and we don't have an answer to that.
Well, according to the plan, it's not, Your Honor. But
Told us that. We just can't find that in the record.
well, they didn't at the Board of
We're
the
kind
Board of
running in a
Adjustment.
circle here. Do you notice?
Right. Yeah. At the Board of Adjustment, they really, they weren't really concerned with actually going through the criteria and determining whether this is a special circumstance or not. And that was their job to do. They didn't do it. There is not evidence in the record to sustain that finding, and that's why you have to reverse, in my mind, Your Honor. And I'm out of time.
Thank you, Mr. Lesotho.
Thank you.
Good morning, Your Honors. I am Michael Niederbaumer. I'm Assistant City Attorney for the City of Tempe, and I represent the Tempe Appellees. I do not represent Mr. GIGUERE, who I notice is not here today. And before I specifically address some of the arguments of the appellants, I must first reiterate to the Superior Court, reiterate that the Superior Court and this court are specifically limited to the record. I think everybody here has already alluded to that fact. Is that
Pretty much.
And we figured that out.
Yeah, I agree. So I just obviously like to reiterate that.
And just to make
Yes.
clear, the record that was made in front of the hearing officer was never presented to the board, correct?
I don't believe it was, Your Honor. Everything, I believe the entire record that was presented to the Board of Adjustment has been presented to this court by way through the record that was transmitted by the Superior Court. The
Transcripts of the hearing.
That would be correct, as well as I believe the application, as well as the report put together by the Tempe staff. And on those lines, Your Honor, and the reason why the record before the hearing officer is generally not transmitted up to the Board of Adjustment is because the Board of Adjustment holds a de novo hearing. So it's as if it was brand new. So what the hearing officer said, what the hearing officer decided, what the hearing officer reviewed is not really that important in regards to how the Board of Adjustment accepts evidence, reviews the evidence, as well as applies it to the law.
Well, except if there's testimony that's presented to the hearing officer that would flesh out the facts that we just went over that we may find are woefully lacking in this case, that evidence could just be presented in the form of, here's the transcripts from the hearing officer for your consideration.
Yes, I believe it could be, Your Honor. If the transcripts from the hearing officer were presented to the Board of Adjustment, I believe it then becomes part of the record that the Board of Adjustment can consider in making its determination whether a variance is warranted.
Mr. Lasota, I think in response to Judge McMurray's question, explained that there was contradictory evidence in the record that would contradict the statement contained in the Ms. Lesser's memo to the that's in the record about the the property would require the house be placed further back on the lot where existing easements and overhead power lines limit placement. And he asserted that the demo map, which I have right here, and I'm looking at it, showed the house where it should have been built, and thus that contradicts the statement that it was. The implication of that statement is that it's not possible to build the house farther back. That's the implication in the statement. And he asserts that the demo map or the demo schematic reflected that the house could be built farther back, and that would be contradictory evidence. Do you agree?
I do not agree with that, Your Honor.
Okay. Why?
Looking at, I'm no engineer, but looking at the map, to me it doesn't look as if it can be changed. But primarily it's because even if there is contradictory evidence down below, I think this court, as well as the Superior Court, was limited in how it could interpret the facts.
I'd like to just talk about the facts. I understand what the law is here. I really do. I really do understand that if there's a conflict in the evidence, basically, decision goes to the Board of Adjustments for the most part, unless it's a legal issue. I get that. But do you agree or disagree that the demo map on its face conflicts with this statement? That's my question.
I disagree with that, Your Honor.
And the reason is
that I still believe that if you look at the map, that placing the house back further would interfere with the easements and the power lines.
So when we say interfere, it would violate those easements, thereby putting Mr. GIGUERE in additional problems.
I believe so, Your Honor.
And where do I look in the record for evidence or testimony that explains to me that this by itself is contradictory evidence?
There's nothing there's nothing in the record to show that is contradictory evidence. I mean, the both maps, like the engineering plans as well as the raising plans, whichever way you want to put them, they're part of the record. But there was nobody that was pointing to the Board of Adjustments how it was contradictory. There was nothing in the record indicating that the cumulative effect of the right-of-way, as well as the non-existence of a sidewalk, as well as the easements, as well as the overhead power lines, affected any other property in the neighborhood. There's just nothing of that in the record. So right there's nothing contradictory to that statement that was in the report, and I believe Ms. Lesser had stated on the record.
So what do we do with that? That's fine to say, But first off, whose responsibility was it to make that record?
The responsibility to make the record, I would believe, is anybody that has an interest in the proceedings. For example, I do believe Mr. GIGUERE had the duty to present evidence as to why his variance should be granted. I believe that anybody opposed to the variance also had a duty to show why the variance should not be granted. The city, I don't believe, really had a duty other than making its own recommendation. It could put its own evidence in, but the city really, though the city here recommended a variance, there was nobody there at the hearing presenting legal argument or presenting evidence other than what is required by our internal operations and our ordinances.
But wait, you said that the city was there to provide a recommendation.
Well, the city provides a recommendation through the report. A report is
Does that just flip a coin recommendation, or do they need to justify that or legitimize that through application of the law to the facts of the specific case?
Yes, Your Honor, they do. They review the law and they review the facts as they at least know them, and they make a recommendation based upon their review of the facts and applying it to the law. And so, but they do not necessarily present evidence themselves other than the the application as well as the recommend or the report that they submit to the board.
You sit in on those meetings?
No, I do not, Your Honor. There is not.
Would you start?
Well, Your Honor, the city attorney does not sit on Board of Adjustment meetings. I hate to say, but right now, as I said, nobody advocates one position or the other than what would be in the report and the recommendation, but no one actually, I would say, advocates, make arguments for or against, other than what's in the report.
Against, not for or against. Wait a minute.
Oh, I'm sorry.
Not for or against the issuance of the variance, or not for or against the position of one of the parties?
They will recommend whether a variance should be granted or not, but they will not advocate other than making that recommendation. And so if this case they recommended no, they would have just placed that same thing in the record, and they would not have advocated for one side or the other than submitting its report.
Well, and the way I understand the hearing is they were there actually to answer questions of the board as it relates to the variance, correct?
That is correct. The staff is there for the board to ask questions regarding both procedure as well as, well, what the staff did to review the application. But, Your Honor, I would like to clear up a couple of things. Mr. Lasota, in his arguments, was discussing Pawn First, and I think he's referring to Pawn First versus the City of Phoenix, the 2016 case, as opposed to the earlier 2013 case. And he indicates it was in both his brief and today that Pawn First stated it required exceptional circumstances for a variance to be created. Though they do cite and they do quote Ivancevich, which made those determinations, I'd just like to point out to the court at paragraph 23 of the decision, this court said, to grant a variance, the board must find that because of special circumstances applicable to the property, including its size, shape, topography, location, or surroundings, the strict application of the zoning ordinance will deprive the property of privileges enjoyed by other property of the same classification in the same zoning district. And it was quoting ARS 9462.06 G2. And so, though I do believe they did talk about exceptional circumstances, I would concur with the appellants here that variances should be granted. Not every time someone asks for them, that they should be relatively rare, but I disagree that it should be as unique as appellants believe they are to be. I believe that variance can be granted to subsets of properties within the district, because as the way that I read the case, if it if a hardship applies to all of the properties, well, then no one is entitled to variance. If that exact same hardship applies to everywhere, they're not entitled to a variance. If a small subset, meaning, and I don't know how you quantify this number, but a small fraction of properties have the same hardship, I do not believe that they are excluded from a variance just because a couple of other properties within the same zoning district have that same exact hardship.
And clearly, I'm sorry, did you have something?
Well, you finish up.
Clearly, the record indicates that the city of Tempe had previously granted variances for the same issue.
Well, for a couple of the same issues, Your Honor, with the extensiveness of the right-of-way as well as the lack of sidewalk, there were other variances granted in this vicinity, being on this street as well as a couple of other neighboring streets that allowed for structures, primarily being carports, being placed within the setback. But the record is devoid of whether the easements and the overhead power lines equally apply to everybody throughout the neighborhood.
When you say throughout the neighborhood, are you talking about the whole district or just along one street or?
And when I say the whole neighborhood, I'm talking about the neighborhood in this particular case on the street.
15th Street?
On 15th Street, yes, Your Honor.
So these are people that are living basically side by side down a street.
Yes.
And of those, however many there may be, 3 of them at least have applied for variances and gotten them. But we don't know if the variance was granted because there were power lines implicated in the back of the property, or simply because the distance to the right, the distance to the property owner's property line, that would be outside the right-of-way, was problematic.
I believe Ms. Lesser indicated that it was because of the right-of-way and the sidewalks. There was no mention when she was discussing these variances whether or not the power lines applied or whether or not any easements applied.
So the
At
right-of-way...
the back of the property. So just,
To the-
I'm sorry.
Yes, Your Honor, to the back of the property.
And the right-of-way itself was apparently determined to be a sufficient specific circumstance, or special circumstance, excuse me.
That is
to
correct.
grant the variance.
That is correct, Your Honor.
Thank you.
My question is this. We've been talking about our standard of review, and that we would normally defer to the findings or the conclusions drawn by the Board of Adjustment. But that's based, I think, on the assumption we've all been operating under, is that there's evidence presented at the Board of Adjustment. Going back to some of your comments about the role of the city in its presence there, Ms. Lesser made, on behalf of her department, a recommendation. And as we've been discussing, there are some statements in here, such as existing right-of-ways, easements, and power lines. But why is that evidence? This isn't under oath. She's not there. Why is this evidence? It is a report. It is a recommendation. But what makes that evidence versus a letter that maybe one of the neighbors submit? I mean, what is evidence for this?
Your Honor, I think evidence is anything presented to the board. And the reason why I say that is it really hasn't been discussed in the cases, and I wish I could point to a specific case. But there are cases out there that discuss that though the Board of Adjustment does a de novo review, they do not have to swear people in under oath.
Well, none of the individuals who made statements on this hearing were sworn.
That is correct, Your Honor. So everybody was, just presented, just spoke before the board, or if there were letters, anything that was in the record.
They gave their perspectives of what they were seeing and how the property and its evolution. I've read it.
Exactly, Your Honor. That's why I think, and we even discussed before, whether or not if a transcript of the hearing officer proceeding was presented, I believe that would also be a part of the record that the Board of Adjustment could consider because it is placed before them to consider it. I know they're quasi-judicial in the fact they're administrative agency. They weigh facts and they apply it, to evidence. But I don't believe they are bound by, the rules of evidence, and they're not as strict as what would be in the Superior Court. I believe everything I wanted to discuss was discussed today, unless anybody has any further questions.
Yeah. Thank you, counsel.
Thank you, Your Honors.
Mr. Lasota, how about if you take 2 instead?
Even better, thank you.
Hang on a second.
Oh, I'm sorry. I was going to wait for it to tick down to 2, but that's,
Go
thank you.
ahead and make your argument. We'll even waste another 17 seconds on it.
Okay. Yeah, and both of these are in the record. I realize that these are maps, but this is the one I was talking about, the site plan as built. And if you do look at it, it shows the setbacks on here, and it shows a gap between the 15-foot setback in the back and where the house ends up right here. So there's a space right there which indicates that the house should have essentially has got more space to move back, or it could move back legally. And this is in the record. And you can also see we've got the gas line, CT, overhead. Overhead comes into the house here. And if you look at the demolition site plan, which is also in the record, you have new house on here, and new house respects the actual 20-foot setback. Well, I don't think the setbacks are actually identified, but it is, you can tell, even a layperson, and I'm not an architect or anything, but you can actually tell from the map that you could put the house back in the setback, and that is part of the record that was presented.
The way I understand in reading what was presented, if you move the house back 10 feet, you would only have a rear setback of 5 feet.
Your Honor, that's contradicted by the map that's in the record. The site plan as built shows a space between where the house ended up and the 15-foot setback. You've got 15 in back, 5 on the sides, and 20 in front. And the house ends up...
As it's currently built?
As it's built. So it is, the house is, according to the
that's
site...
right. So if you move it back 10 feet, if it's 15 now, you move it back 10 feet, then that would be 5 feet, right?
No, Your Honor. It's 15 plus this space here. This space identifies the 15-foot setback, and you've got the house that is well off of the 15-foot setback. In other words, there is a space between the 15-foot setback and the house. Now, it doesn't identify the length of the space, but you can tell with the naked eye that it is the exact same distance between where the house ends up being built here and the 15-foot setback, exact same distance that the house juts into the 20-foot setback. In other words, it juts 10 feet into the 20-foot setback. That's shown here, and it's the exact same distance from here. You can easily extrapolate that's 10 feet.
But Mr. Lasota, and I'm sorry we've gone over time, but this is my concern. You've just led me through and explained to me how I'm supposed to look at this, but that was never presented to the board.
Judge, Your Honor, that's accurate, and but I think that just goes to the fact that there's simply not evidence to conclude that the special circumstances, but also that the strict application of the zoning code is what deprived Mr. GIGUERE of the ability to build the house that he wanted. I mean, I think the evidence actually did show, and it was part of the report. So, I mean, if we're going to accept what Ms. Lesser says, that we're going to consider that 2 lines about this is a special circumstance, and we should also consider the plan that was actually submitted to them, and that essentially shows that it was not the strict application of the zoning code. It was just Mr. GIGUERE's inability to comply with the code that prevented him from even if there was a special circumstance, it prevented him from the other privileges that his neighbors and people in that zoning district enjoy. So,
thank you, Mr.
Thank you.
As you can see, we do enjoy our oral argument, and it's worth our time to get
Probably more than they do, right?
It is worth our time to get the answers that we need. And thank you, counsel, for that well-informed oral argument. We're going to take the matter under advisement at this time. We will be issuing our decision in due course. Thank you for the argument. We're adjourned.